fixed on the
But in fact, they should go before the
Oh, I didn't see you. I missed. Just
Well, he just now came, Milord.
My lord, Article 35 was directly by one of the candidates. The Supreme Court deprecated, no, you go before the High Court first. And another matter, my lord, the High Court.
This channel does not promote or encourage any harmful or illegal activities. All contents provided are strictly for educational and informational purposes only.
And those conditions under which he had participated. Once he has participated under a rule, he cannot challenge the rules to be unfair if the promotions have not been made as he would have wanted. This important aspect is the promotion have taken place as per. Now, once he has appeared, then he cannot challenge the rules. Second point, my lord. Similar, just I did tell you, very short, the fact is, in the Orunima Pal's case, entire rule was challenged. The entire rule that was dismissed, here dismissed, even in the Supreme Court it was dismissed, except in certain portion. Then, my lord, successful candidates, untainted teachers also filed so many petitions in Supreme Court. Either challenging the Orunima Pal's judgment and other judgment, also Article 32. Supreme Court is examining the entire rule. And that is fixed on 24th November.
this 2025 rule.
Yes.
Nobody has
Yes.
submitted this.
No, they have not said.
I said, Bharat, yesterday I did say. I
They
said
said.
that Purnima.
Now, my lord, what I would be.
SSC dismissed, but whether this rule is under
Yes, yes. Yes, my lord, I will show. If your lordship give me time, I will.
some saying no, some saying yes. What does the court?
My lord, in that case, give me some time. I will show you the petitions also and whether there are submissions. My lord, may I just take it from me, my lord? Just take it from me.
Not under
Please, Mr. Dasgupta, all you have taken time. My lord, the Supreme Court has said, kindly take it from me, on 24th November or whenever they met, entire thing would be scrutinized. Second, that is, I leave it to your lordships whether your lordships will examine it or not. I am telling your lordships the fact. Therefore, this is, my lord, everything is under the scrutiny of the Supreme Court. Just I tell your lordships this. My lord, I will be requesting to your lordships that give a direction, sir, to move them under Article 32 before the Supreme Court, because so many multiplicity of the litigations are not expected. Whole rule can be seen there. They can go under Article 32 also when this is being looked into. This is the one of the part of the matter objection, and also it will not be rather proper at this stage by the High Court to go into this. Third is a delay. Well, delay maybe 1 year delay, maybe 6 days delay is also factor. If at all, without waiving my submission that they cannot challenge the rule, they could have come earlier. They did not come earlier. Your lordship was still observing just a change of determinant. That is the last week. 3 or 4 months, they have not challenged it. Today, we are going to publish the only candidates who appeared in the written examination with their marks. Nothing more than that. Thereafter, my lord, the verification will be done within 7 days. 7 days or 10 days, just take it, my lord, at that time. This is one group. My lord, only 11, 12 will be published today. 9 and 10 will be published within 2 or 3 days. But this argument I have also made in the Supreme Court also. Supreme Court has given us time, that's all right, you continue with this. Verification, etc. But then after verification, what stage is coming? Before interview? Yes, before interview. First, I have to verify that whether any teacher who has, any candidate who has applied and passed in the examination, whether he is the eligible or not. Let's take it, there are some cases, we have given it, said it in the Supreme Court. Supreme Court has also given us the liberty. Some cases, maybe some tainted candidates have been missed. Let's just assume, for argument's sake. But at the verification stage, we can also say, we can also detect them, cancel. Similarly, the untainted teacher who are claiming untainted teachers altogether, whether they are all untainted or not, that would be verified at the verification stage. After the verification stage is over, now Lord kindly come to the rules. The lordships have gone to the rules. Kindly come to Lord page.
স্যার আপনি আইটেম নাম্বার 2 না 3 তে বলছেন?
ভাই আমাকে তো যেটা বলছো যেটা চলছে লিস্টে দেখাচ্ছে সেটাই তো করছি। Anyway, subject is same. But inter 2K, kindly see 2K. Interview list. Interview list in respect of the SLST state level selection means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration categorized on the basis of the preliminary merit score from written test and or TT for AMRA so and so and academic score in the ratio of 16.1 final vacancies. And this academic score you will find here the policy schedule. Schedule 2. Well, along with the prior teaching experience. Therefore, interview this preliminary merit score and also academic score. Then you will also kindly see merit list. 12. Merit list in respect of the SLST state level selection test means in case of post, a list of candidates prepared category wise on the basis of merit which shall mean and in addition to what has been stated in Rule 2K marks obtained in oral interview, lecture divination and prior teaching experience shall include all the eligible candidates. That is a wide definition. And at the time of preparing of the merit list, we will take into consideration all things, everything. That doesn't mean that the prior teaching experience is not included within the 2K, because it is within the academic. But that has been more clarified what Mr. Mitro was submitting under Rule 11K. Therefore, today before a lordship is 2K, today before a lordship is 2L, and today before a lordship is 11. That Mr. Mitro was submitting, that 11, Roman 8. The Central Commission shall prepare and publish its website a preliminary list with details of the candidates to be called for interview, subject to verification of credentials and eligibility, categorized on the basis of the preliminary merit score as defined in Rule 2(1)K in the ratio of 1.61. Malad, your lordship notes the rule of interpretation. There's a harmonious construction. And with the court object is not to destroy the rule. Court object is to preserve the iron. Now, kindly similar, your lordship takes this tip very clear. First is written examination result, verification, then the academic score, then it comes below the interview. Interview what? That's the two stages are there, oral interview and the demonstration is there. This is the case. But there I cite one judgment to your lordship. Only take this, give it. The 2000, Justice Malami says, Dipankar, the 2024 SSC online 3776. Two 2024 SSC online 3776.
24 SSC online 377.
Kindly come to paragraph 6. The contentions of the appellants are not acceptable. This has in fact been dealt with by the High Court. The condition stipulated in the corrigendum is no manner. Sorry, I am very sorry. Kindly excuse me, Miller. Kindly excuse me. I am very sorry. Sorry. I have given a wrong citation and I was in 2024 SSC online 3776. Kindly come to paragraph 24. I'm very sorry. In state of Rajasthan versus Sannam Lodha, this court was considering whether absent a challenge to the law or rule, this same could be read down answering in the negative. Honorable R.B. Ravindran J. So it is true that any provision of an enactment can be read down so as to erase the obnoxious or unconstitutional element in it or to bring it in conformity with the object of such enactment. Similarly, a rule forming part of an executive instruction can also be read down to save it from invalidity or to bring it in conformity with the avowed policy of the government. When courts find a rule to be defective or violative of the constitutional or statutory provision, they tend to save the rule wherever possible and practical by reading it down by a benevolent interpretation, rather than they declare it as unconstitutional or invalid. But such an occasion did not arise, and in this case, there is no challenge or to the validity of the Rule 5 so and so, and therefore of the view that in the absence of any challenge to the Rule so and so. Now let us come to the prayer of the petitions. Kindly see. Page 21. It is Shishir Das. A declaration. Can you say declaration declaring that the respondent authority and its agents to abide by Rule 21K and Rule 21L of the West Bengal School Service Commission, appointed to so and so, and the rules to thereby awarding prior teaching experience after the interview round in connection to the recruitment process 2025. His interpretation is this should be done after the interview. Our interpretation of the rule is this, that it has to be done before interview. Therefore, he has not challenged the entire rule. He is asking the marks should be added after interview. And according to our rules, our interpretation is before that. Now, next, second, a writ of in the nature of mandamus to issue commanding the response their agents, servants, subordinate employees, assigns not to award marks for prior teaching experience in calling a candidate for interview in connection to the recruitment process. Therefore, Millard, today, I don't know, Millard, whether what is your lordship's mind is, whether your lordship is finally hearing the matter or, Millard, we have to file an affidavit, no doubt about it. And at this juncture, the question of passing of interim order does not arise at all. That will absolutely allow the writ petition itself. Millard, kindly remember one thing, Millard, we are running against the time. That is the whole difficulty we are seeing. Yes, that day also I was telling to a lordship's man. 31st December, I have to declare the result in terms of the Supreme Court's order. Malad, with great respect, I tell you, with great respect to your lords, any type of intervention in this matter will nullify the order of the Supreme Court by 31st December 2025 has to be done. And prima facie, I have a case I have shown to your lordship. This is the case. And I will request and beseech to your lordships. I will rather beseech to your lordships in this matter. So many applications, so many writ petitions have been filed. Why they are avoiding Supreme Court now? That's much I am telling you. With a guarantee I am telling, everyone is avoiding Supreme Court. Give them leave to file before the Supreme Court under Article 32.
Please
Any
show
sorts of
document. Please show me some document that this issue is pending before the Supreme Court and 24th is the date fixed for hearing of this.
In that case, kindly take it on 12th. I will show you.
Yes.
No, there are so many. Please show me.
The copy of the SLP is required to be produced before your lordship.
He's showing something. Let him show.
Let him show something.
Millard, I will show that the Orunima Pal's judgment, where Orunima Pal's judgment, the entire rule has been upheld by the division bench, was challenged by them.
This was placed
That
yesterday.
I placed yesterday.
Well, we placed it yesterday.
The entire thing should come to rest after. Because this 10 marks granting or not granting the division has held, and it is not arbitrary.
My points have not been dealt with in Aruni
That's
Gopal,
the
what I have said.
point. The question was whether that particular rule was arbitrary or not.
Was the rule under challenge?
Yes.
One order from my CAN application.
You have a copy of the, no, this order. Have a copy? Please check up.
Yes.
Page 24, this line was placed yesterday.
And then she's 34.
1 minute, please, page 24. Sixth sentence, the recruitment rules has not been challenged by any of the appellants.
That is not
Incorrect.
probably not correct.
See, this is the court's order.
Yesterday it was shown to your lordship.
Your lordship is
Yesterday it was shown to your
This
lordship.
line was also
Lord, with
shown.
respect,
And in the single page.
they with you, Mr. Bandyopadhyay showed it to your lordship.
Yes,
I wanted to
Right.
show the prayer of Urunima
Lord, please see paragraph 28 of this division bench. Please see 28.
was under check.
It was.
but thereafter not proceeded with.
Yes.
No, before the division bench,
There is a difference.
There is a difference
Yes.
between not challenging at all,
Right,
but says
and
I
abandoning
challenge,
it.
thereafter just a second.
see the prayer.
Challenge and thereafter I find I don't want to continue because of XYZ reasons which may not be suitable for me, so I give up.
Yes,
This was a case of given up, and that was recorded by the division bench.
my lord, all the councils,
respect of one, in
my lord,
respect
kindly
of
see,
one candidate who's not a party over here,
Correct,
right?
correct.
So the court, when the litigant gives up the issue,
Yes.
the court doesn't have any scope and an occasion to.
Look into that.
no, that is your lordship is absolutely correct.
Correct, correct. No
My
doubt.
lord, your lordship is absolutely correct.
Matlab there
But
are-
what I am, my lord, that is your lordship is absolutely correct. My lord, whatever it may be, ultimately it will be decided by the Supreme Court. There, my lord, Article 32
Ma'am,
petition is,
after Mr.
Article
Bhatt.
32 petition is
I
maintainable.
don't take soft copies.
Article 32 petition is also maintainable. They have moved so many Article 32 petition.
What is pending in 20?
Because time is a very important factor here. That is the reason I am saying. Otherwise, I would not have argued this point, your lordship. Your lordship is having all jurisdiction powers, everything to examine whoever the litigant is approaching before your lordship. But here is a case, your lordship knows this, the entire thing, that if your lordship, then of course, if your lordship entertain the petition, we will file an affidavit, thereafter matter would be heard. But
No,
any
this is
type
a
of
point
interim,
of law. This is only interpretation. There is no affidavit to be filed because factually nobody is denying or
no,
disputing.
not only one thing, kindly record that I wanted to file an affidavit, but affidavit is not required. Your lordship makes this interpretation.
According to me, everything is.
Well, I have to put on record all these documents. What your lordship is saying, where is these documents, where are that other documents that I have to place it before your lordship.
The Bandyopadhyay is correct. Your lordship kindly come to page 41
Of
of my CAN 1 of Shishir Das matter. Item number 3.
can one din to dekhi.
Can one bin na?
Page?
Can one.
Page 41.
My lord, with your lordship's leave, may I go, my lord?
Dekhi Shishir Das
কেউ যাবেন না?
No, my lord, with your lordship's leave, may I go, my lord?
রিট পিটিশনের নামটা দেখুন না।
চলে যাচ্ছে কেন?
শ্রী দাস ক্যান ওয়ান এটা কোনটাতে?
This is CAN 1, your lordship.
স্যার একটু থাকুন।
পেছনটা দেখুন। শিশির দাস।
But every.
My lord, with your lordship's leave, may I go, my lord? With your lordship's leave,
Price of the Supreme
can I go?
Court.
Can I go, my lord? With your lordship's leave, can I go, my lord?
Yes, Mr. Bandyopadhyay, certainly.
My lord, deeply obliged.
Everything.
All right.
Issue is completely different. I tell you.
1 minute. Some Mr. Sanyal was showing, sir.
41.
41.
Sleep over page 41, 42. Have a look at 43 only.
Yes, 43.
এর ড্রপ কত?
Property portion next page, page 44. the last paragraph, the matter need not be listed on 31st October or 31st October. Even if specific dates have been given in any of these batch of matters, as they would necessarily have to be heard together. We are informed that the results of the selection test held on 7th September 2025 and 14th September 2025 would tentatively be declared in the first week of November 2025. List on 26th November
24.
26th is mentioned. 24th.
So, all these have been applied.
Oh, my lord, the issue
Oh,
is-
oh, 1 minute. Page 41 that you placed is a matter of Vivek Paria. Where is
Place that order yesterday also.
Vivek Paria? Was it placed?
Yes.
I cannot.
We have given a copy of.
So because every matter, a bunch of matters were heard by the justice. Bhattacharya, the jurisdiction bench presided over justice. All points are equal.
Because Orunima Pal has been highlighted. I cannot recollect that now.
Yesterday, Arunima Pal was highlighted.
Yes.
Division bench and several different. Vivek Paria, my lord, the issue was whether there was a criteria 45% has to be,
No.
there was no 45% or 50%.
Incorrect.
Challenging that division bench negate, no, the qualification fixed by the.
And Mr. Mitra appeared for Vivek Paria before the High Court.
Listen, thing is whether this 10 marks
No.
prior teaching experience, this issue was hard.
Why not let the SLP copy of the produce, whether this 10-mark issue is in challenge in those SLP.
Even yesterday, you lost SLP copy. Paragraph 12.
Whether this 10 marks
Point
can
of
be
law, oh,
point of law grounds, kindly see the ground.
And
Showing one.
an issue has been raised as to why do not you take it up before the Supreme Court, the whole thing.
Court fixed, fixed on the chart. But in fact, this should go before the Supreme Court.
Oh, I didn't see you. I missed. Just
Well, he just now came, my lord.
My lord, and Article 35 petition was moved directly by one of the candidates. The Supreme Court deprecated, no, you go before the High Court first. And another matter, my lord, the High Court refused to entertain. Supreme Court said, no, you first decide. That is why, my lord, your lordship will find all are special leave petition, not a single Article 32. All are from special leave petition. Why not let the copy of the SLB, if their candidates are appearing, their
in
client,
Vivek,
let the copy of the SLB be produced before your
Vivek,
lordship.
you lost the SLP copy.
Yesterday.
Given.
I've given you a loss.
is it there in the file? All right, I'll check it up.
Here is kindly remember the
Wait.
point of law number 12, ground number 12. Now, other point, each point is pending before the Supreme Court. My legislature was asking that whether we are out of expiry of the panel appointed candidates or not. If so, they will be tempted. Now, please order the
1 minute. 1 minute. Vivek, SLP, which ground and
ground number 12.
ground 12.
Ground number 12.
All right.
I put a tick mark for the loss.
All right. All right.
Yesterday has been given the SSC of Orunima. Orunima was hard with Vivek. I will show to your losses there. It's a bunch of things.
Was Vivek's SLP given or not?
Your losses can even look at all the matters are hard analogous.
No, but then is it in one matter
But
only?
what happened? There are a bunch of writ petitions, hard and disposed of by the division bench. One SLP was taken together, another SLP was moved there.
No, Arunima Pal's SLB was only restricted to certain points and Vivek was restricted to certain points. Your lordship
The fact remains, my lord, the entire thing is pending before the Honorable Supreme Court.
The entire thing. There are issues.
My lord, this issue, the issue which is being heard.
Show me something.
Keep it on Monday, produce the document. Keep it on Monday.
The other points
Yeah,
are
because
the
Monday,
panel we are not. Canada will look at
Monday,
this order.
But why will the court look? The commission is there to look into it.
No, I'm showing to your lordship that everything is before the Supreme Court. It's right.
Yes, and the commission is the authority to see who are in the panel, outside the panel, all these things.
Point was asked in this writ petition. Justice Bhattacharya in the single bench said we cannot do it because Supreme Court is in.
একবার দেখিয়ে দাও তো।
Yes, whatever
Then
the
Malad went on appeal.
Division.
Appeal court justice, division bench presided over Justice Papabotto Chakraborty held the same view.
My lord, that has been challenged. That has been challenged by the list was challenged by tainted candidates. So we do not fall under those candidates. Completely different, my lord. Your lordship can consider the writ petition. It will be clear to your lordship.
Yes,
Paragraph 10 and the operating portion of the order.
It's considering about tainted candidates. Kindly see what was the issue, my lord. Kindly consider
Question of
that.
law, it's a question of law. Stating 10% of.
Yes, question of law. Then why it is pending before the Supreme Court? I also say it's a question of law.
And the operating portion, your lordship, of the order.
Well, kindly read the order, the issues raised in that writ petition. Completely different. একদম যারা untainted তাদের নাম পরীক্ষা।
Candidates were allowed to continue their service, but they were appointed after expiry of the term. And their names do not feature in the list dated 30th August. This is exactly the submission of Mr. Dasgupta today before the process.
no, their submission is that the commission is to see who are tainted and not tainted.
He is arguing that these sort of candidates are coming within the zone of tainted.
Yes.
That submission, so this is the same argument.
No, that is completely separate and nothing has to,
I'm saying
nothing to do
each
with the
of
10
these
marks.
points are now before the Supreme Court.
That is the eligibility factor which the commission will consider, whether they are eligible or not eligible. That is not the issue.
That is different.
Qualifications, not these ones.
No, the Supreme Court has said
That's one of the other.
will be able,
Cannot be allowed at all.
yeah, that is also an eligibility.
They're one of the points. The 2
The
points are
points.
involved.
Yes, so that the commission will see. That is not the issue.
They are arguing
That-
whatever argued before your law.
These are not very relevant. What is important is whether this 10-mark issue is pending before the Supreme Court. Please show yesterday. All right, I'll check it up.
My lord, may I?
And the issues also. In a very short and a concise manner. Otherwise, see the documents over here, yesterday's.
My lord, you have said, see this is judgment of division bench, where this point was teaching 10 marks were raised or not. Please see paragraph 6.
Which one? Which judgment?
This is Showman judgment.
Orunima Paul?
Yes, see paragraph 6.
This
can we
is
come to
16th July's judgment.
paragraph 6, I have shown yesterday. Then paragraph 6 middle. Mr. Bhattacharya submitted because in the middle. It is submitted that prior teaching experience for 10 years was not an eligibility criteria in earlier notification. Moreover, the percentage of marks has been arbitrarily increased from 45 to 30. This is the second point. And made malafide make them disqualified. Otherwise, you can in terms of now, similar when this matter comes up before the High Court, I mean to the learned bench, what they're considering, what they're saying. No, but I think court is being misled. দেখো বার করে দাও এখানে কোর্ট হোল্ড করতে এখানে প্যারাগ্রাফ 34 ছিল paragraph 34 can you see now?
Paragraph 34 has been placed yesterday.
Yes.
Today also it has been placed, and
I've
one
seen.
line is also there that the recruitment rule has not been challenged by any of the appellants.
My lord, but it's not challenge.
It is written over there.
দেখো
The 6th line from the top,
My lord,
page number 24.
my lordship may look at from this point of view. It is possible.
Yes.
There are
Awarding of marks. Awarding of 10 marks is a weightage.
No,
be
page
given-
24, page 24 of the judgment.
It's
that you have
24 years, 24, Can
6th
you-
line from the top.
Yeah, lordship is absolutely correct. I've seen.
24
See,
years.
Yeah,
What is passing through the
I-
court's mind?
my lord,
But the
can I
good
just
item
conclude?
between- where we
I
look-
began. There are
The
two
prior
just
teaching
conclude.
experience is an
Not this-
important factor. If prior teaching is an important factor, the experienced teacher may impart education effectively and efficiently.
Next line.
Recruitment rule 225 has not been challenged by any of the applicants. I'm not challenged, but argument was made.
Suppose it is not under challenge, somebody comes up with an
Let me not challenge, just see.
I have.
Still without-
I
has not been
have an
challenged.
answer to that, and I don't want to take an extreme view. My lord, when
But
a
not-
rule particular, act to volume, please. Just not, let us not go for
34 has been placed, Mr.
30,
Chatterjee.
30, 30.
Well, I don't want
That
to,
has also, Mr.
Well,
Bandyopadhyay yesterday has
I
placed
don't want to
everything.
say, I do not want, please, I do not want to say in that way. Kindly see two things. I do think there is an every possibility, because I'm not going to say I'm 100% confident, but my hunch is there is a possibility that the entire virus of the rule may not be challenged before the Honorable Supreme Court. This is true. At the same time, this is also true that this is a unique situation, unlike other SLPs and civil appeal, where because of a gigantic nature of impact governing the matter, the Honorable Supreme Court is, without using the word monitor, is effectively, I'm using effectively, trying to see that my order is actually complied with. So therefore, I do not say that if anyone questions the virus, Lordship doesn't have power to enter it. I don't think. I think one can independently question virus, which is a purely point of law, possible, unless it is purely covered. But there is also a thing called a propriety. Now, when the Honorable Supreme Court, in a very unique manner, in this case, is trying to ensure it is complied with, what does it mean? It means we have delivered a judgment, that's the Honorable Supreme Court. Thereafter, X, Y, Z things were our directions. Are those directions being complied with? Now, at that juncture, I do not say that it's legally, I would be able to say that Lordship doesn't have a power. Lordship has power. But even if Lordship has power, Lordship may afford to say, I don't want to enter at this stage because of propriety. It's not because lack of power. This is number one. Number two, if Lordship wants to see this, because something has to be before your Lordship shockingly wrong. There is a clear-cut judgment by the Honorable Supreme Court in 2024 involving this prior experience. It was by, now kindly have a look at there. This is, it's not page, no, it is not page. This is, kindly see, 2024 SCC online 3776.
It has been given by Mr. Bandyopadhyay.
I know that, but the other para.
Para 45.
I have this. Kindly see, exact, this was.
Bandyopadhyay cited this judgment on the part.
Yesterday this was
Let us
placed.
have that.
Today he cited.
Yes, I know that.
Para
Oh,
45.
today. Oh,
Ki-
then it must be here. Yes, Allahabad University is here.
Yes, kindly
Hiruddin.
see
Yes.
paragraph E at page 3.
Yes.
Paragraph 2E. Kindly see the procedure. Well, there are synonymous words are always there. This is a judgment where the weightage, that's the prior experience, was used for the purpose of shortlisting even. That is pre, which is the case here. E, the procedure for shortlisting candidates for interview is given in the note to regulation 4.1, which provides for shortlisting on the basis of an academic score prepared in, kindly mark the academic score, identical case of ours, with table 3A for universities. Well, just pause. What is table 3? That is paragraph 40. Kindly come page 26, paragraph, page 26.
Yes.
Serial number 7. Teaching, postdoctoral experience, 10, 2 marks. Similar method. Now kindly come back to the same paragraph, 2F. So this table 3A, there also teaching experience was there, and 3B. Hence, for shortlisting candidates for the purposes of interview, Allahabad University would score candidates as per the criteria laid down in table 3A and the affiliated college, such and such. As per clause 7 of table 3A and 3B, 2 marks are to be granted to a candidate for every year of his or her teaching experience or postdoctoral experience. Since the contents of both the tables are similar, we propose to reproduce, they are reproduced. Then G, despite respondent number 1 fulfilling the eligibility criteria, she was not shortlisted for the interview as her score did not reach the cutoff marks. This happened because she was not awarded the marks under that 3A. Kindly straight away come paragraph 48. because the division bench took a different view, single bench took a different view. The division bench view was set aside. Paragraph 48. We are also of the view that the criteria for shortlisting of candidates as engrafted in table 3 and 3B were in furtherance of the entire scheme of frame by the UGC for appointment on the post of assistant professor in university as well as in college. Clause 7 of table 3A and 3B, having direct relation with regulation 10, did not call for any observation from the division bench of the High Court of the nature noticed above. An aspirant satisfying the conditions in regulation 10 would be entitled to marks either for teaching experience or postdoctoral experience for which a cap of 10 marks is imposed. Regulation 10 on its very terms makes it clear that rendering a past service, well, this is important, law point. Rendering a past service is not a sine qua non for direct recruitment. If indeed a candidate has served in the past and answers all the conditions that regulation 10 envisages, read with clause 7 of table 3 and 3B, as the case may be, he or she would be entitled to marks for teaching experience. In such circumstances, we hold that the division bench completely erred in appreciating the contention issues in the proper perspective vis-a-vis this. Now, similar thing also 2025 Justice Gawai judgment in our professions. My lord, now if a lawyer wants to sit in the judicial examinations, a freshers, I have LLB, so therefore I am entitled.
The
Now-
district judges.
Now experience of three. Kindly have a look at this judgment of Justice Gawai. This is justice.
Justice.
Copy touch. Well, I'm yes. Kindly take 2025 SCC online SC 1184. Well, if I can just say my premise, I say that there is no reservation for freshers. So therefore, it's a competition. In a competition, selector has a right to choose if the pool is available, whoever I think to be the best. Putting experience as a criteria as something which gives a leverage is recognized by the Honorable Supreme Court in variety of matters. Now this 25, kindly take my lord, paragraph 89 Roman 7 at page 32. Even the direction was that amend all the rules of all the high courts. Romans 7, last para. All the high courts and the state governments in the country shall amend the relevant service rules to the effect that candidate desires of appearing in the examinations for the post of civil judge, it's not district judge, civil judge junior division, must have practiced for a minimum period of 3 years to be eligible for the said examinations. Kindly, my lord, contrast this way. A person desiring to sit in the examination, in this case, is not even be able to appear at all, unlike this case. A freshers who doesn't have a reservations, he would be able to participate. But he will not be getting
A job.
Yes, no, he will not be getting the experience marks.
That means he will not
But
get the
no,
job
if
also.
he's a brilliant, kindly look at this way. If he's a brilliant, in a sense, if his academic marks are much higher, then he will get. Kindly look at my lord from a, I would say, from a point of view, because both sides may have a story. Both may be reasonable. Now it is lordship would see which is more reasonable. One side is saying that our scope is being choked. That's the freshers. They are going to say this is choked. The other side is that there is a judicial recognition of experience and marks, and that is Justice Dotto's judgment. So therefore, it is very well possible for a selector also to say that you must have some experience. Without doing so, they have diluted it. They said that if you have experience, if it is a prior, if it is in a government, because they mentioned in a government or aided school, then you will get 10 marks. Does it mean it is completely choked? My answer would be no. yes, it is reduced, competition becomes more. But that is, my lord, that is for a reason which is not unreasonable. It is not unreasonable because in judicial examination, experience has been, because fundamentally,
Tell me something, if
Yes.
it is, if the issue is pending before the Supreme Court, the court will not look
it is,
into
it is, it is, it is.
First,
No.
second, this issue, 10 marks. Other issues, it may be pending. The court is not concerned because that has not been placed.
We'll come back on this.
That
Well, I-
is
Court
what-
has also said,
But
my lord,
that is the
but-
first thing that
But
is
to say
staying in the
something
mind.
with a full confidence, then I have to get hold of
Somebody
these.
must be there
Yes,
having
yes.
documents to show.
Must be, my lord, I said is that this teaching experience point is not pending before the Supreme Court.
SLP.
Not the SLP, the original writ petition.
Original, nothing.
They have to bring original writ petition in which.
Yes, one is fixed on the 26th.
As well as the writ petition.
The learned article.
My lord, what happens, that technically it might be possible that the point of when is not there, but prior experience was there, that is clear. Whether prior experience was there and that 10 marks is entitled, that is there is no doubt about it. Question is, these two things.
Why don't you all see, you all are filing so many applications, petitions and everything, get some order from the Supreme Court.
Yes, yes.
Which
Well,
permits
that's-
this court to look
well,
into
that-
this issue.
That's the propriety. Well, that
My lord,
is
this
the
is the cause of action which was available to them, my lord, in the month of August.
My writ petition, my cause of action was not available.
My lord, he sat for the examination, keeping his eyes closed.
But the rule says that there is a possibility that the 10 marks has to be given at the preparation of the panel. In my challenge, whether the 10 marks are to be given to 2016 cancelled appointees.
It is on 26 November. This is the ground.
Bench to individual issues in the advertisement, right? Whether can be looked into by the High Court when the issue is pending before the Supreme
well,
Court.
at this juncture.
Just take,
Even an arbiter of division bench is binding on single bench.
you please get
Even
this
even-
type of orders.
Madam,
I am keeping it next week because 12th the matter is already fixed. In the meantime,
yes,
please,
on Monday.
This is the ground.
in the meantime, you try to get order from the
Please, Sadhu Khan, আমি এটা দেখাচ্ছি।
High Court to get it done.
SSC
Or
number
no will not do.
082 দেখাচ্ছি। আমি দেখাচ্ছি, দেখে নিন।
Nothing is pending before the Supreme Court.
My lord, Obhijit Sadhuka, I just now, my lord, got.
See, all different names
My
are
lord,
coming.
difficulties, my lord, there are n number of matters. The only ploy of the petitioners are to come to your lordship's court at the last moment.
segregate
They were of the rules, my lord, these rules were promulgated in the month of May 2025.
Somehow what they have failed to do directly, to do it indirectly to
This is
accommodate
completely beyond their readings.
tainted candidate.
Completely beyond their readings.
What do they gain out of it?
Sir, that is, the gain is to stall the process.
What do they gain?
That is the only gain.
This is unfortunate.
That a
This is
commission is saying such thing, my lord.
Yes,
That means the commission, we are not equal to the commission.
This is a
Not
with all due respect, this is a political statement.
This, they are also
This is not expected from a commission.
anything out of the whole
That
thing.
shows that commission is not treating us equally.
All the process, they failed.
Much shows.
Not the matter.
The results are not
Kindly
declared.
visualize,
We do not
the
know what
Supreme
their
Court has
position is.
directed us. Mr. Chatterjee produced orders. It says, my lord. Yes, please.
My lord, that would be the
Best
I
course
feel,
of
my lord,
action.
that would be the best course of action. We get hold of all the SLPs, copies and the orders.
Either keep
Otherwise,
keep it on
otherwise,
12
I'm not saying
or
lordship
earlier.
doesn't have power. I say,
And whatever y'all rely upon, please circulate with the petitioners so that they also get come prepared. Otherwise, again, John,
I will give.
there is a timeline within which things are to be done.
Correct.
Diary number টাও আছে।
Kindly have a look at the one.
Diary number
First, yes,
instead of
has service of the cans been made to the commission?
I believe that this is not a application on 32 blood. That they must bring the writ petition in which it was originally challenged. Instead of the SLP. But SLP, they cannot expand the scope of the writ petition. Therefore, they have to produce the writ petition. And the second issue, We do not want to jumble it.
Keep it on 10th and Monday even.
All that, today,
They cannot come prepared.
today my simple prayer is the whatever issue pending is not so far this when at what stage this marks to be given is not pending for the Supreme Court. Now
What stage
today,
to be given? That's right. That's right.
today they may publish the result or list of candidates. One line order is required from this court that whatever result they publish, that would be subject to the result of the writ petition.
We are opposing that.
Otherwise,
No, it goes without saying.
goes
Opposing the
without
prayer.
this will not prejudice anybody.
Yes,
That goes without
My lord,
saying.
even if your lordship
Lordship can
does not
always
receive-
ask.
even if your lordship does
do
not
not see from you
Issue-
this type of submission. is
time,
not
he
acceptable.
is-
No,
he is,
2 November, it's all right.
Lord, he is making this submission. He is, my lord, requesting.
He
the-
is,
May I point out only one sentence? I hold my breath. But only one sentence apropos of the interim order that is being prayed. But in the notification itself, employment notification itself, it was made clear that the participation is without intending to create any equity or right to any
Yes,
party.
it
who
goes
may
without
choose
saying.
to apply.
that is not subject
that
to the
is all right, but that is the ultimate. That is the ultimate. Empanelment does not create any right. It's that type of thing.
But if any thing is done today, that can be undone, number one.
Yes, yes.
Won't create any right.
That is always subject to the
Yes,
result
always,
of the writ
always.
petition.
Yes, that kindly record.
Sadhuka SLP office, kindly have a look at the ground. Look,
8 and 9.
Kindly have a look at the ground.
Yesterday, it was not there.
My lord, yesterday it was not.
Who was
Well, let that be considered on 12th.
I think we should reserve our energy for
How
12.
many cans have you supplied to Mr. Bandyopadhyay?
I have also not received the
I have supplied except state.
He is appearing for the state.
State,
Then
Lord, even, my lord, the
It is-
commission has not received any
it
application.
they,
My lord, the applications have also not been received by the commission.
they, commission has not received your application.
Only can 5 I find.
Yes, the lucky one. What about your can? Please serve.
State I will give, commission I have given.
No, commission has not got.
Have the copy of the.
One thing, all pleadings and copies should also be served upon us.
Yes.
They are ready.
Lordship may pass exactly the same order.
Yesterday that was passed earlier.
Council has received all.
I cannot hear you, sir.
I'm on behalf of the intervening applicants, my lord.
Again, intervening applicant.
Yes, my lord. It is a can 4 of today's item number 2. I just want to indicate that, my lord, I am led by Dr. Maneka Guruswamy.
Yes.
She could not appear today, my lord, due to some difficulty. My lord heard yesterday the same application. I just want to indicate, yes, I just want,
Appearance 12th, it will be heard.
yes, my lord.
যে যে মামলাগুলো আর কি শুনানি হয়েছে না ক্যান স্কুলেও সে নম্বরগুলো কিন্তু দেবেন দিস ইজ আইটেম নাম্বারস 2 and 3 together. Heard submission made on behalf of the petitioners, comma, the applicants, comma, the state and the school service commission. The issue relates to the recruitment notification published by the School Education Department on 29th May 2025 for selection for appointment to the post of assistant teachers in junior high, comma, secondary and higher secondary schools. Stop. Submission has been made by some of the applicants that the issue raised in the instant writ petition is pending consideration before the Honorable Supreme Court. Stop.
Lordship may use effectively pending.
The provisions of the rules, namely the West Bengal School Service Commission bracket open, selection for appointment to the post of assistant teachers for upper primary level of classes, bracket open, third bracket, except work education and physical education, third bracket close, comma, classes 9 and 10 and 10 and 12 and 11 and 12. Rules. Rules এর আগে bracket close, comma, 2025. Page number 79, এখানে রুলের নামটা আছে, দেখে নেবেন। Date আছে। Stop. The learned advocates representing the petitioners denies the submission. Stop. It has been submitted that not a single writ petition challenging the above rules is pending consideration before the Supreme Court. Stop. The paragraph, the specific issue that has been raised today is questioning the stage at which the 10 marks allocated for prior teaching experience is to be awarded. Stop. Whether the same is to be awarded prior to preparation of the interview list
Preliminary interview.
or prior to the preparation of the
Merit list.
merit list. Please find out whether there is any description of preliminary
Yes,
interview
yes,
list.
eight itself.
No, not 8. The definitions are there.
No.
Definition whether preliminary
The rule
list is there.
11 mentions preliminary invitation.
Where is it described?
Rule 8,
But it is described
Sub
as
rule 8.
interview list.
Interview
It's
list.
not
Interview.
The sub 11-8, 11-8.
Is it prior to interview or post?
It's 11-8.
Further
Mention.
issue that has been raised,
Under 11 rule 8 says, all right. It mentions preliminary
is
list.
whether not whether, is the justification of leaving out the in-service teachers of private schools from the realm of consideration of the selection. Stop.
Experience of secondary education can be used in higher secondary.
The experience of using the experience of teaching students in the secondary level to be used as experience for teaching candidates, not candidates, students in the
Participant of secondary, senior secondary.
for in classes 11 and 12.
My lord, whether 2016 appointees will get those 10 marks.
Stop. It has been highlighted that if 10 marks is added to the candidates who appear for teaching in level 11 and 12 to the in-service candidates, then the freshers will never get a chance to be appointed.
Yes.
Another point argued whether 2016 candidates will get the
Rationality.
It has also been questioned as to whether the examinees whose selection in the year 2016 stood null and void by the order of the Supreme Court would be entitled to the benefit of 10 marks for the prior teaching experience. Stop. That apart, paragraph, the other points have also been raised, but the broad heads are mentioned herein above.
One more, the demonstration 10 marks given at the time of preparation of merit list, and there's 10 marks for teaching experience. For the same reason, 10 marks again in demonstration. That's the rationality part I have
That's the
taken
logic part, not the point.
to challenge that rules.
I am not going to all these. ওটা থাকছে প্যারাগ্রাফ একটা দিন, the parties are directed to exchange all pleadings and documents to be relied upon by them at the time of hearing, so that none of the parties is taken by surprise at the time of hearing. Stop. Copy of all intervening applications shall be exchanged. Stop. The parties are directed to produce documents in support of the submission that the issues framed herein above are pending consideration before the Honorable Supreme Court. The matter is fixed on the 12th of November.
That they will provide the copies.
It is served. No issues. If not served, please serve.
My lord, only
Lord.
request, my lord, your lordship has been kind enough to record your commission submission also, my lord, that the writ petition is not maintainable at this stage, my lord. The point of maintainability be kept open. We have also cited judgments.
The
Mr. Bandyopadhyay has.
Respondents
Debo.
issue regarding maintainability of the writ petition is being decided by the court, and it is kept open.
On the last line I have prayed for.
Last?
That I have prayed for, that result of the writ petition.
Yes, yes. It has been brought to the notice of the court that the result of the written examination is due to be published today. Stop. As the issue is pending, as certain issues with regard to the awarding of 10 marks is pending consideration before the court, the result of the examination will abide by the result of the writ petition.
Grateful.
Petitions.